Justice and Justices of the Supreme Court of Michigan. All persons having business before this honorable court are admonished to draw nigh and give their attention. The court is now sitting. God save the United States, the state of Michigan, and this honorable court.
Good afternoon. We had a long morning. We have 4 cases on application this afternoon. Again, you have 15 minutes each side, and after 2 minutes, your free fire zone has been lost. Let's begin with People versus Comer.
Good afternoon, Your Honors. Jacqueline Ouvry from the State Appellate Defender Office, along with Jacqueline McCann at council table. On behalf of Mr. Comer, I'd like to reserve 3 minutes for rebuttal. I can keep my own time. Your Honors, you should reverse the decision of the Court of Appeals in this case because they ignored the plain reading of MCL 750-520N, which requires that the sentence was valid in this case because lifetime electronic monitoring does not apply in Mr. Comer's case, where the victim was over the age of 13. Additionally, the trial court violated the court rules and due process by modifying the sentence in this case outside of the time allowed. This court should reverse and overrule the decision in Brantley. The Court of Appeals ignored the plain language in Brantley of 750-520N by ignoring the phrase "for criminal sexual conduct" within that statute. That phrase gives meaning for 2 reasons. One is that is a modifying clause that modifies the entire series of 520B and 520C, which tells the reader that the following phrase, the age limitation phrase, also modifies the entire series. The additional reason that the phrase "for criminal sexual conduct" has meaning under the 520N statute is the differentiation between the word conduct in that statute and the word contact, which is used in the CSC2 statute, which is 520C2B. 520C2B uses contact, which is limiting. It does not include penetration, which the word conduct used in 520N would include penetration and would point the reader to both CSC1 and CSC2. With that, I don't believe I have any free fire time left, but I'd welcome the court's questions.
Are there no questions?
Got a lot of time for
Certainly, if there are no questions, I also want to address the issue of the interpretation of the court rules in this case. Certainly, the court can decide and should decide this case to include a valid sentence under 520N. This court also should apply the court rules and find that the Court of Appeals decision in People v. Harris should be overruled to the extent that it gives unlimited authority to a trial court to modify a sentence at any time. Under our court rule 6.429, authority to modify a valid sentence is not granted, but authority to modify an invalid sentence is given in 2 sentences within that court rule. First, the parties must file a motion within the time limits. The second sentence says that the court may modify a valid sentence. This court should read that the court rule does not permit modification of a sentence outside the time limits for direct appeal.
Why?
Because this court has acknowledged that in People v. Holder as well as in People v. Lee, that inside the period for direct appeal, the court may file a motion, just as the parties may file a motion, but outside the direct appeal period, which is what occurred in this case, the court is bound by the rules as well as by due process to not disturb a final order of sentence. And the Court of Appeals got it wrong in Harris.
Do you have anything further? Okay, well, thank you then.
Thank you.
Thank you.
Good afternoon. May it please the court, my name is Hillary Georgia, and I represent the people of the state of Michigan. I'd like to start out talking about MCL 520N, and I think that when you look at that particular statute, 520N, it is only really ambiguous if you read it in isolation. And I provided the court with a handout that just lays out the statutory language, and I apologize for being oversimplistic in doing that, but I think that when you look at these three statutory provisions in conjunction with one another, and they were all passed or amended in a tie-barred process through the legislature, and I think that shows that they were meant to be read together. But 520B is very specific in its terms and does not include age-limiting language. When you go down and you look at 520C, it does include, let me back up. 520B does say that the defendant shall be sentenced to lifetime electronic monitoring under Section 520N, so it references 520N. But 520C not only references 520N, but then includes age-limiting language. And the language of 520N merely mirrors 520B and 520C. There is no age-limiting language as it relates to 520B. There is in C. So I think that when you look at all three together, it's evident that that age-limiting language was really only intended to apply to Section 520C or to CSC seconds. Because there is no age-limiting language in the CSC first statute, I think that it's evident that there was not an intent to limit that there. If we were to read 520N as, if we were to read the age-limiting language in 520N as applying to both 520B and 520C, we essentially render that ending sentence in 520C, it's surplus, it's redundant. There was no reason for there to be a distinction in the way 520B was written and 520C was written if we're just going to cover it in 520N. And I think that if the court looks at these statutory provisions together as they were intended to be when they were enacted through the tie bar, it's really not as ambiguous as if you just isolate 520N and look at it that way. I think that when we get into the discussion of the rules of statutory construction, the last antecedent rule, the series qualifier canon, all of these things that were discussed in briefing, those really don't need to be reached by this court because I think the overarching principle here is that the statute needs to be read in context with other similar statutes within the same chapter. The greater issue of concern, particularly in preparing for oral argument in this case, is actually issue 2. The court's ability to correct the sentence. And if the court finds that the sentence in this case was not invalid, then obviously we don't reach issue 2, but I'd like to discuss it just a bit because I think it's important that the trial court has a mechanism by which to address an invalid sentence. And I don't disagree that the language in MCR 6.435 is not particularly favorable to my position at all. But I think that when you look at 6.435, it's entitled correcting mistakes, and mistakes being mistakes in general, whether they be an order, a judgment, a sentence, any mistake.
Counsel, I just have a question.
Yes.
Why is it, I mean, at the end of the day, if it can be corrected by either side, why is that problematic if it's a substantive issue?
It's problematic because either side may not correct it. And I didn't really realize the import of this until I spoke with an individual at the MDOC, and she pointed out to me that back in 2005, there was approximately a 30% error rate in the sentencing judgments that came from the courts. There was actually an audit by the Auditor General that talked about this issue and tasked the time computation unit with this purpose of going through these sentences and actually figuring out were they correct. And there's not really a check from the prosecution standpoint. I know defendants receive either appointed counsel or they have someone that reviews their sentence as a matter of appeal, but there's nothing similar from the prosecution standpoint.
What do you mean?
And certainly not from the, I'm sorry?
You mean the prosecutors don't know what a correct sentence is?
No, I don't mean that at all. Prosecutors certainly can catch a mistake. What I meant was after someone is sentenced, a defendant generally goes through the appeal process having someone appointed to examine the sentence.
30% sounds like an extraordinarily high amount of error rates for sentences.
I was surprised by it as well, and I was happy to hear that it is down and hovers around 7% now. That was, again, back in 2005. The only reason I bring up that statistic is because there are a number of mistakes that are made in the sentencing process, and they don't just benefit the people or just benefit the defendant. They really are kind of equally weighted. And there were a number of things that were provided to me by the MDOC where errors could come up, errors in consecutive versus concurrent language. There have been errors in calculating the statutory maximum that work both for and against defendants. A lot of errors in terms of imposing too much or too little jail credit. Again, GPS requirements like the first issue in this case.
But counsel, I guess my question is, where's the hardship? I mean, ultimately, if you're amending a sentence and the sentence is substantive, I mean, that can have a significant impact. So shouldn't this be a formal process?
It should be a formal process, and I think that under this court's decision in, I believe it was Miles, the court emphasized that there needs to be notice, there needs to be a hearing. The court can't just receive a letter from MDOC and unilaterally, on its own initiative, change a sentence without notice to the parties. I don't mean anything I say to suggest that this should just be done by the court without participation and notice to the parties.
Just notice or notice in a hearing?
Notice in a hearing, yeah. I felt that the two kind of go hand in hand, but I'm sorry, you were going to ask me something?
What significance should we attribute to the fact that before the amendment of 6.429, it began with the court may correct an invalid sentence, the same provisions in there, and was amended apparently to make it possible for parties to do so as well?
I think the significance of that is to give the parties the ability to bring the issue before the court if the parties notice it. I think that when you look at the language of 6.429, a motion to correct an invalid sentence may be filed by either party. It's not the use of a more of a word like shall. It doesn't require.
I mean, I don't understand why you focused on that textual clue.
Because
my concern is that some have interpreted the fact that there is an addition of a method for parties to challenge an invalid sentence to be a limitation on the court's ability to do so, which was unfettered and clearly so before the provisions to allow parties to do so.
I guess the reason I pointed to that sentence is because I think that provides the avenue for the parties to file it, but then the next sentence is the court may correct an invalid sentence.
Yes.
And I think it gives you two separate avenues. It can come before the court by way of a motion for the party, or it can, looking at the second sentence, it can come before the court on the court's own initiative. It would obviously be helpful if it said on its own initiative, but I think that...
It didn't have to say on its own initiative before there was a right for parties to do so.
I don't think that it needs to say on its own initiative, because it just says the court may correct an invalid sentence, but may not modify a valid sentence.
Why doesn't it need to say on its own initiative? Almost everywhere else, I think, in the rules where we allow the court to do something on its own, we use that language. Why would we omit it here?
I don't know.
Which is why I asked you the drafting history of the rule. Before the amendment, it began the court may correct an invalid sentence. After the amendment, that sentence was preceded by a motion to correct an invalid sentence may be filed by either party.
And the previous motion, unless I'm mistaken, did not include the on its own initiative language. But I think if I'm understanding your question, why would they put a sentence in before giving parties the option if they didn't?
I think it was quite obvious. There wasn't a clear provision that allowed the parties. I think the defendant previously had a right somewhere in there, but that first sentence was to make clear that either the prosecutor or the defendant could move to correct an invalid sentence. It was added before the sentence that I read, which has been unchanged since. So my question is does that provide any textual clue as to whether the second sentence is somehow constrained by the process that was added to allow the parties to make a motion.
And no, I don't believe that it constrains that second sentence of the court may correct an invalid sentence. I think, again, it just...
Do you think it odd, if that's interpretation is correct, do you think it odd that the rest of the rule goes on to delineate the procedure for the parties to file a motion, but says nothing about when, for example, the court may correct an invalid sentence? I mean, I don't think it would be your position that the court could do so 20 years after the sentence was entered, do you? Or the judgment was signed?
Initially, when I reviewed this matter, I thought that there needed to be some constraint on time. However, again, after I talked to the MDOC and realized that they're now going back and looking at all of these sentences, I don't know what time frame you would want to put on
So if you're
that.
the defendant and you've been sentenced and you served your sentence and then you've been released and then you're done, the court could go back and say, whoops, we made a mistake. You're actually, I meant to give you 5 more years. And then you go.
I think that's where I'm sorry, I didn't mean to.
No, I'm just trying to, how does this work? There has to be some finality, in other words, right? And there's some due
Is there
process.
no point
right?
at which finality overcomes the court's ability to do this?
I think finality is important, but I think that, again, and usually my position is arguing from one of the importance of finality, but when you have a sentence that is invalid in some way, whether we discover it 4 months after sentencing.
I mean, arguably, if it's invalid in a way that prejudices the defendant would have other avenues to seek relief, like ineffective assistance of counsel, right?
The defendant always has other avenues.
So we're mostly focusing on, and it's kind of interesting because you've talked about the MDOC procedure, which I'm very familiar with, and I agree with you. There was a very high error rate. I'd like to think not out of my court, but out of the trial courts. And so we worked very hard through SCAO and MJI actually to educate judges to try to bring that error rate down. But the chief, I thought, pointed out or brought, really brought the point into focus. Why isn't this something that prosecutors do? That they review these judgments of sentence to make sure that they're correct, that they're not invalid, and that they do so in a timely manner. In other words, under the current rule, they have 6 months to figure it out. So why doesn't the Attorney General have someone who's designated to review judgments of sentence? Why do we have to offload this onto the MDOC and have clerks there who aren't parties to the case looking at the judgment? Why is that system the best one to have? I mean, that's the system we have. I understand why it evolved that way, but why is that optimal?
I think your point's well taken. I don't mean to suggest there's no duty on the side of the prosecutor, be it individual officers or the Attorney General, to not work toward ensuring accuracy. But there was this report that was generated in 2005 that talked about the role of the MDOC here, and I think part of it's because the MDOC isn't a party necessarily. The MDOC is going to look for errors, look for accuracy. I think the parties are obviously in the best position to catch it. But
counsel, doesn't that, I guess my question is, and I'm asking this in a more kind of theoretical perspective, doesn't this kind of elevate the court in a way that goes against our system? You know, ultimately, like, you're kind of elevating the court to become more of a third party rather than a neutral party. I mean, shouldn't this really be left up to the individual participants to be able to do this?
No, I don't think so, because it's the court's judgment. It's the court's judgment of sentence, and if there is something invalid about that judgment of sentence, if neither one of the parties catches it, I think that it would be wrong.
I understand, but isn't this, whenever you're doing sentencing, there's an entire process that you kind of go through, and it's still part of the kind of adversarial process in terms of, you know, you're going to have your pre-sentence report, and you're going to debate and discuss it, you're going to go back and forth, and, you know, you're going to put forth arguments. So in a way, like, doesn't your kind of argument somewhat kind of prejudice the way the system functions, which is, you know, you argue your side, they argue their side, you know, a sentence is entered, and then isn't it really the responsibility of both sides to then determine if the sentence is in fact valid? Just like every other aspect of the trial is up to the individual participants to make certain.
It is up to the parties. However, we do have this mechanism through the MDOC where they, in their time computation unit, notify the court of errors. And if neither one of the parties has caught the error.
authorization for the trial court to correct an invalid sentence.
I'm sorry, I just didn't hear the first part.
I said the court rule is some expression. We're trying to figure out how broad, but it itself provides the court to correct an invalid sentence, which an invalid sentence may be an injury to the defendant, but it is an injury to the state itself to have an invalid sentence entered.
Correct. And I guess that's my point. An invalid sentence is an invalid sentence and a problem in and of itself, not necessarily the responsibility of either party specifically, but...
So let me ask you this. What is the MDOC, what is it acting? When it audits sentences, which is essentially what it does, is it acting as an arm of the court? Or is it acting as an executive branch agency responsible for housing prisoners and so forth?
I don't know if I want to call it an arm of the court, but my understanding...
Arguably, when they do the probation, the pre-sentence report, when they're probation officers, they're acting, even though as state employees, they're acting as at the court's direction, right?
And it's in an advisory capacity to the court, particularly after this court's decision in Holder. These letters from the MDOC are meant to advise the court, and then the court must comply with the court rules in addressing them. But the whole purpose of this time computation unit...
But advise the court as an executive agency now, or advise the court as an arm of the court? And does that matter, and should that matter to us?
I don't think it should matter, because I think that the import of it is that they're fact-checking, they are checking sentences, they're checking length of time, they're checking accuracy, and they're not doing it for the benefit of either party as an advocate. They're doing it just to make sure that the sentence imposed is valid.
But going back to Justice McCormick's question, do you not have a concern, I guess, do you not have a concern that there's no end to this? So that a person, they conclude their sentence, and you then always have to worry that this could wind up coming back. I mean, can that be a concern? That, like, I mean, do you not see, like, a concern? I mean, is this a concern that you don't have, or is this a concern that's outweighed by other things? But the idea that you could literally live without any finality, and they could be changed. Let's say they discover it, 50 years from now, and you moved on with your life, and you're doing good things. I mean,
Moved out of life.
Yeah. I mean, I guess the point is that really something that can be appropriate?
Are you envisioning a situation where someone has been sentenced, has served their sentence, has now left the MDOC as a prisoner, is now discharged from parole, and your concern is that at some point in time, someone at the MDOC will go back and review that file, find an error, and then that person will be dragged back into court and resentenced?
Yes. Is that something that's possible?
I think in a theoretical sense, it could be possible, but from what I know of the way MDOC is reviewing its cases...
What is the constraint, not DOC, what is the constraint of a court to go back that far? After all things, isn't there some constitutional limitation here?
It's not going to make us feel better to say MDOC isn't that aggressive, because that's not quite.
We want a legal response. Is there some legal constraint?
There's not a legal constraint as 6.429 is written. I think there can be due process concerns, and I think that those are important.
Legal, right?
I'm sorry?
Due process is still legal, right?
Yes, and very, very significant. But I think that that's where the notice and the hearing provision comes in.
So if 50 years later, if we get notice and a hearing, that's okay? That's not an offensive due process?
No. I'm not...
So due process might require something more than that at a certain point?
In that particular case. But I don't think that the court rule is telling you...
You're not helping yourself by saying this is an incontinent process that can go on forever, subject to a notice and hearing.
And I don't think that it should be...
Well, why don't you just tell us why it can't be that way?
If the court put a time limit on it, but I don't see that there is one.
Thank you.
So let me just ask one more question. Assuming that I would assume there's some due process constraint on how long this can go on, but if accuracy is the most important value, which is sort of what I'm getting from your presentation. And I'm sort of a perfectionist myself. I kind of like that outlook, or at least for my own psychological limitations, haven't been able to adopt a different one. But if that's the most important value, then why in the world would we limit the prosecutor to 6 months for filing a motion? Why wouldn't we say, look, prosecutor, if you figure this out 2 years down the road, we want accuracy, so bring it on. Why should we just hear from the MDOC, this quasi-judicial, quasi-executive agency?
Because I think there could be an argument that there would be some tactical reason for waiting if it's a motion from a party. A defendant or a prosecutor, we would hope, would not use a tactical advantage, but I think that's why you have to limit.
Couldn't the prosecutor game the system just the same, because they know that MDOC is going to send out these correction letters? So they can sort of count on those at this point, right?
You mean would the prosecutor fail to act and then expect the MDOC
Well, you're
to?
talking about gamesmanship. It just seems to me.
No, that was the only reason I could think of why we need to limit the parties, because they're advocates, they have motivations, whereas the court's motivation would be justice and accuracy.
And the MDOC's motivations are pure.
Are what?
Pure.
I would hope. But they're not aligned, I would say they're not aligned with a party.
May I ask a question on the ground? How long does it take MDOC to review these sentences? I mean, are they spitting out errors from 50 years ago?
No.
Or are they processing them generally within a 6-month time frame? Or
No.
what are we talking?
I would say it's within months. It's not.
Well, what happened in this case?
In this particular case, just to give the court the exact dates, there was an initial sentencing in October of 2011, and it was remanded by the Court of Appeals for a second sentencing in October of 2012, so a year later. But that had nothing to do with MDOC. That was just an offense variable issue. The second sentencing occurred again in October of 2012. There was an MDOC letter sent in January of 2013, so roughly 3.5 months after MDOC noted the error, alerted the trial court, and then the court got it scheduled on within.
Are the parties given a copy of this?
Yeah.
Would then be an ex parte correspondence?
I believe that the court gets a copy, and then the parties also have a copy.
And neither party made a motion?
No, neither party did.
Well, that's weird.
So did the prosecutor waive this issue by not bringing a motion, even though they were put on notice?
The first time, I'm sorry, was there?
No, they had the opportunity to do so, right? They were still within the 6 months from the judgment of sentence that's at issue in this case, right?
Correct, but the first time that the defendant was sentenced back in 2011, Brantley hadn't been decided yet, so the court's sentence was not.
No, I know. I'm not
Wrong.
really that concerned about what happened in 2011, I don't think.
You mean
Maybe I
in
should be.
2013?
Yeah.
No, between the time that MDOC sent the letter and the time that lifetime electronic monitoring was imposed, there was no motion
Should
for
it impact
prosecution.
us that the prosecutor had an opportunity to file a motion properly under the existing court rule and decided not to?
And had noticed, apparently had noticed from MDOC that there was a problem.
They did.
Should that impact our ruling?
It could. I certainly understand the court's concern that the prosecution may have had notice and did not file something. But
Would you say, just to change subject, because I think we're going to get to bring this to conclusion, but you started off saying this was the difficult issue in the case. It sounds to me like you would concede that this rule does not really contain all that you would like it to contain to authorize trial courts to do what you would like them to do. Is that a fair statement?
it's certainly not as clear as I would like it to be, no.
You might draft it a little differently.
I guess the language of on its own initiative would be helpful, and I do appreciate
Maybe some time limits, some procedure for this to happen that would be consistent with the Constitution?
I'm not opposed to a limitation of time on the court's authority, but I do think that it needs to be recognized by the court that sometimes errors don't
Is it the
come
kind
to
of thing
fruition.
we should think about in a different process, like an ADM process, and get input from more lawyers and more people? And
Yes. I think that in terms of people that could be affected by the court's action as it relates to issue 2 is far more widespread than issue 1.
Okay, thank you very much.
Thank you.
Several minutes.
You don't have to take them all.
Thank you. What I want to address, I think, are the overarching concerns that this court has with the problem with the court rules. And that it
Sorry,
has to
can
do
I
with the...
interrupt? The crier should note there's 2 minutes to go, not 10 minutes and 29 seconds.
No,
No,
she
she
didn't use
actually-
any of her time, remember?
she
We didn't ask
But
her
you
any
reserved 2 minutes.
questions. Oh, sorry.
Did you not reserve 2 minutes?
I did reserve 2, Your Honor.
Okay. Okay.
Okay, please go.
Interesting interpretation.
We'll be flexible with you.
Thank you. With that being said, I still think that the overarching concern is the role of the court with these court rules. And I think the answer to most of your questions is that the role of the court is not as an actuarialist. It is our functioning in imposing sentences is for individualized sentences. And
Well, we
not
want those
accurate or
sentences to
valid
be
ones.
accurate, right?
I said our overarching concern is individualized sentencing. Accuracy is a concern, but it's
And
not the only
validity.
concern. Validity is a concern, but it's...
But not an overarching concern. We want judges to just individualize invalid sentences. That's our highest goal.
That is not our highest goal.
Of
Our goals
course
for
it is.
sentencing are the protection of society, the rehabilitation of the defendant,
And we don't want
deterrence.
courts to enter invalid judgments or sentences.
Yes, and we have rules that guide that, and the rules are 6.429 and 6.435, which are not unlimited rules. And the rules are limited by due process and finality concerns, which at some point limit the court's authority. The Court of Appeals was incorrect that it's unlimited authority in Harris, and the authority should be limited by the direct appeal process, and anything outside the direct appeal process should be weighed by due process
Why does
concerns.
Harris not say that?
I'm sorry, Your Honor?
Doesn't Harris say that the authority of the court to act isn't limited by the party's authority?
That's where Harris should be overruled, is that
Why?
it gives no time limit for the authority for the court to act. It's-
Why is that wrong as a matter of the text of the statute?
It's a constitutional error because of due process, and it's wrong by the text of the court rule because the first sentence of the court rule, as Your Honor pointed out, now changed, says that the parties must file a motion, and the prosecutor did not file a motion in this
So your view
case.
is the court does not, on its own initiative, have any authority to correct an invalid sentence?
The court's authority, the
On
court
its
does not have its own authority outside the direct appeal period. If this court found that it does, it's limited by due process and finality.
But what's the due process problem in your client's case? Because your client, it is not the situation where 20 years have passed, right?
still serving a
It was
sentence.
timely. He's still serving his sentence, so obviously he's not. So what's the due process concern in your client's case? Is there one?
Yes, and it was not timely. There was no motion by the prosecutor.
Right,
and-
there was no motion, but so let's say that the MDOC had served, given the court notice, as they did, the notice was given to the parties, and then the prosecutor had made the motion. It would have been fine, right?
So if the prosecutor had made the motion, then the court would have the authority. If they made the motion within the 6 months, the court would have the authority to grant or deny that motion.
So your
There's-
due process argument boils down to the statute doesn't explicitly give the court the authority to do what the court did.
That and the court acted outside of the time limits because the resentencing that occurred in this case occurred outside the 6-month time period. And the sentence was modified without motion and outside the direct appeal period.
And so your argument is, so what's your argument about what's the outer boundaries of constitutional limits on the time during which a sentence could be modified?
Without a motion, only during the direct appeal period.
Well, why is that the constitutional rule?
Because
I mean, I don't know why the Constitution dictates that. And shouldn't whether it's on motion or not on motion, if we're concerned about the defendant believing, for example, this is my sentence, let's say you're sentenced to 20 years, and on 19 years and 360 days, MDOC sends a letter over to the trial court and says, you know what, you were supposed to sentence that guy to 25 years. Now we might go, oh, wow, that's a problem. This guy that seems like maybe there's some kind of constitutional problem with the guy's 5 days from getting out of jail. But what I'm wondering about is, it would seem like whether there's a motion or not, or no motion, the time concern would be consistent. And I'm wondering what the time concern is. Is it 10 years from entry of judgment, 3 days from entry of judgment, 6 months, 1 year?
So the constitutional concern, and this court has addressed that somewhat in Miles and Holder and Lee, is that it's based on the nature of the error, and there's an individualized assessment.
But that's not tied to the 6 months in the court rule. You're trying to
Right.
suggest that there's a constitutional dimension to the provisions of the court rule that we gave the parties to make a motion. That's clearly not a constitutional limitation. It's a court rule limitation.
So there's a court rule limitation that is informed by the constitutional due process.
Where did that come from?
From the Constitution itself. And
So what provision of the Constitution do I look for a 6-month period to challenge an invalid sentence?
no, the reason that we have court rules is to breathe life into our due process rights.
Well, what is the due process right? What, for example, is the due process right in the illustration given by Justice Larson? Obviously, it seems like a very egregious and unfair thing to do, but what exactly do we point to in support of the idea that there's a constitutional right not to be subject to that kind of maltreatment?
It's the interest in finality. It's the interest in finality of sentence that resides with both society and the defendant. The defendant has an interest in a final judgment.
Which provision of the Constitution is that? The finality provision?
The finality is part of due process. It's part of that, the process at some point becomes final.
And due process speaks to finality being appropriate up to what point?
It's appropriate, it's an individualized balancing, and
I see.
the due process finality can also be subject to waiver, as it was in this case, where the prosecutor had notice and did not file a motion within the time period, and the court acted outside of the time period. So there's, in addition to simply the court acting outside of the time period, there's the party in this case who had opportunity to raise this issue multiple times and did not. On balance, due process was violated in this case by the modification of the sentence, and by the fact that this was a valid sentence when it was imposed based on the plain language of the statutes involved. For that reason, the Court of Appeals should be reversed.
Thank you very much.
Thank you.